Constitutional Court has ruled that the 31st of March deadline for digital migration set by the Communications and Digital Technologies Minister is invalid and unconstitutional. Now, free-to-air broadcaster ETV brought the case to the Apex Court after the High Court in March dismissed its bid to scrap the government's end of March deadline for the country's migration from analogue to digital television signal. Now, let's speak more about this with Digitally Legal CEO Advocate Zanyiwe Nthatisi-Asare. Thank you so much for your time this evening. Did this ruling take you by surprise?
Well, thank you for having me, first of all. Take me by surprise. Look, I think there's always two sides to all stories. So I definitely see how both ends came about, where we're having this, one side of the party saying this is unconstitutional, it's prejudicial towards our marginalized and disenfranchised, but also from a 4IR, fulfilling SDGs and ITU perspective, understand and see why the department thought it was best to do so. However, there definitely were certain elements that were not considered.
And I'll get to your latter part in just a moment, but let's stay with, what came out from the court yesterday. I mean, we saw some who were reacting in the public domain saying that the minister had taken an anti-poor approach when it comes to the 36% of South Africans, for example, who rely on analog television. Your thoughts on that one?
So those are very strong views, and looking at South Africa's past, there's definitely an argument to have and an argument to strongly consider when making decisions around taking away access to information. If you look at our history, Section 16 specifically says that people should have access to information, and also there shouldn't be any hindrances to people being able to give others information, especially our poor and our marginalized. So, when you look at that and you look at the minister's actions, there's really a plethora of things to consider. If you look at the global deadline, which was the 17th of June 2015, there's been a lot of time that South Africa has had to have these consultations, to speak to the people who could potentially be prejudiced by this decision. And I don't think it's fair to solely point fingers at our current minister. There were, two other ministers that also had a duty to get us to this point. So, there's that argument. Then there's the argument to say, the minister's currently in the hot seat. And even if there was oversight or, alleged mistakes by previous ministers, it's really up to her to carry that and say, how do we ensure that we remedy previous mistakes before we make decisions?
And talking about, the latter part of your first answer and this one, where you talk about this project having been years in the making. I mean, we know that the initial date at some point was, in 2015. There's been a lot of conversations and movement around this that has been happening over time. And we do know, as you say, for example, that this is also going to assist for example, when it comes to people who are disabled, to be able to have better use of their televisions. And these are going to be television sets that have various capabilities. So in this context, would you say, though, that on the flip side of this coin, you understand why government was pushing so hard?
There are absolutely probative values to this move. So, this brings up a conversation of convergence. This brings up the conversation of adequate use of technology and really adopting for you mentioned a very pertinent point. These TV sets or the hardware that will be implemented or used in this digital migration, assisting people with disabilities, people that have really been forgotten and marginalized by technology and technology makers. So there's certainly that element, and also using 4IR for good, 4IR for the change that we're really looking for. If you look at our SDGs, from a global level, and also our 2030 NDP plan, yes, you can definitely see why the government has been pushing for this to really change the lives of people. However, the real question here is, are we doing that without considering all the relevant elements? And here is that, the 2 million households, the 36% that you're speaking about, these are people that we actually need to consider that need that change more than everybody else. So, are we doing this just to tick a box, or are we doing this to adequately change people's lives? And those are the questions that we need to ask ourselves.
And while staying with those questions, then the court finding that it was not procedurally rational for the minister to set the analog switch-off date without notice to, the industry and the affected parties, as you say, and you put it, because this is all part of the judgment. So it's now calling on the minister to consult widely and to really be able to take everybody on board when it comes to this particular project. So what would that consulting widely look like for you?
So wide consultation would really look at everybody who's within the value chain. So that would look at the content developers or creators. So that would be the channels. Remember, there's a hardware component when it comes to the digital migration. So it would be the people who own the channels, but then also the viewers themselves, who also need to have that hardware injection into their homes. And as you mentioned, that 36 million that live below the breadline, those are the people that actually need to be, to be, if you spoon-fed or handheld throughout the process. Now, what that looks like from the governor's perspective, or from the ministry's perspective is for them to go out into the rural areas, for them to go and sit down with the broadcasters, people who are having local television stations, and to understand what is what are your needs? What can we do to assist you to adopt this change? And also for those that are finding themselves wanting in rural areas, as much as we can say that the issue is that they can't get access to set-top boxes, or they haven't gotten them, there's also another narrative that is very real on the ground, that even the same set-top boxes that are out there aren't necessarily working. They are defective. So already, you're saying you're going to help the poor, but despite helping the poor, some of this hardware that you're giving them doesn't work. So all of those things need to be considered to ensure that everybody is ready. And that would need intentional foot soldiers, people on the ground, whether you're going to churches, you're going to schools, you're going to community halls, you're going to the post offices where people are getting their grants. You need to go to the people. And that's exactly the message that I think this constitutional court ruling is saying. Go to the people, sit them down, and take the hardware, the working hardware to them, but also walk them through this so they understand what it is. We can't be speaking for our adoption at a national level without ensuring that there's an element of literacy and people being involved in the movement. As
a final question then, how much of a delay then does this mean for the rollout of additional spectrum?
So look, I can't answer that. I'd love to. But I think what would shorten the time period is certainly cooperation and synergy amongst all the players that report into the department. So once you get all of these other little loose ends out of the way, then you can have that bigger question about when is the right time to a spectrum. You can't talk about rollout, and you can't talk about a migration of anything if we haven't adequately consulted people. So that would really need everybody to hold hands in the ICT sector, ICT ecosystem, to ensure that our poor and our marginalized are really considered and involved in this entire process.
Always a pleasure to speak to you. Thank you so much for putting this into perspective for us and the viewers who are probably wondering what this development means. That is Digitally Legal CEO Advocate Zanyiwe Nthatisi-Asare.